Everything you see around you has a logo on it, or at least represents some sort of business, right? They're called intellectual property or IP. They're everywhere. Well, in this video, we're going to go over some of these major signs and learn what they are and why they decided to legislate them. Stay tuned. I know that people like everything to be less restrictive and more open to use, but the creator or the owner of that art or brand deserves to have financial gain from their idea or creation. You don't want other people to use your idea for free because you don't want to make money out of it, right? To protect your art or brand, there has to be laws to protect your right as an owner of that brand or art. That's intellectual property. And there are many types of intellectual properties, but in this video, we just go over the main ones. The first one is known as the copyright. I'm sure we all know what it means. You must have seen a circle at every website or in every book. It basically protects the art from being used or published without the author or the owner's permission, and then there are penalties if someone caught doing so. The second IP is the trade secrets. This is a good one. You must have seen in movies, oh, what's the secret ingredient? Or even in real life that companies uses a special or some kind of secret formula to make their product. That's known as the trade secret. Primarily, though, no one's going to tell you their secret ingredient, but if they did, they found you trustworthy. But if you go on and tell others about that trade secret, first, you lost the owner's trust, and you can get legal penalties. The third one is the patent. Let's say that you have invented a new way of transportation that no one has ever seen that can change the world. Only you have the design or a sketch on a piece of paper. Patent will protect your drawing or design from being claimed by someone else. For patent to protect your art should have these requirements. It must be new, not obvious, and would have industrial applicability. What does it mean by non-obvious? It means if I bring an expert, they wouldn't say, oh, anyone could do that. That's exactly how it is done. Let's say you want to attach a handle to a cup. That's obvious. Everyone knows how a handle is stuck to a cup. So it will not be protected by the patent because it's not non-obvious. But as I said, you have made something that no one has ever seen. If an expert sees it, they would say, oh, I didn't know it can be done that way. This is non-obvious and will be protected by the patent. The last one that I want to mention is the trademark. You know, people use different names for their brand or their art. Sometimes the name can be general or a common name, like Mr. Beast. Anyone can claim to be Mr. Beast. So what they do, they go on and register the name as a trademark, and it will get this sign on top of it or in the circle. This will protect the name from being claimed and used by someone else, which means no one else can use that name to name their product or their brand. That was all about intellectual property. At the end, all this comes down to one thing, and that is the owner want to have financial gain or incentives for their product or brand. These laws can protect them. I'm sure you want to do the same thing for your brand. You don't want to lose money or you don't want to lose your business. So you're going to protect your name and your brand with one of these intellectual properties. If you found this video helpful, don't forget to share it with friends and family so they can benefit from it as well. See you in the next one.